First off, I would like to thank you for taking the time to join me in the podcast today. It was an absolute pleasure to meet you and listen to your panels at the IP Trade Secret Protection Management Summit last November. Chris is an experienced attorney and the co founder of Tangibly, a platform to help companies manage and protect their trade secrets. As Deminor is seeing more trade secret cases, we thought it would be great to do a session focusing on the top tips of IP protection from his perspective. There is some discussion that companies are looking more to trade secrets than patents to protect some of their technical IP. Can you explain why this might be happening?
Sure, it's a great question to start off on. And there are actually a lot of different reasons why we're seeing this shift from patents to trade secrets. And it used to be that you would just patent everything. Life was simple. Any new technology, you would just file a patent. And almost without thinking, this was the pattern. And what we've seen recently over the last maybe 5 or 10 years is a shift to looking away from patents. And it's really much harder to get a patent in the first place than it used to be. A lot of things, the bar has been raised, or maybe certain technologies that used to be patentable are just impossible to patent anymore. Like, no matter how good your technology is, you just can't get a patent. Patents are also increasingly expensive. They're very expensive to get, and they're even more expensive to enforce. And if you want to play this patent game, you need to have a lot of zeros in your budget. So it's not something that a small inventor or an SME can easily get into because the ticket price is so high. We're also seeing that technology is moving faster and faster every year. And the patent process, as you may know, is pretty slow. So from the time you file a patent application to actually getting an enforceable granted patent can take 2 years, 3 years, 4 years, sometimes even longer. And technology, by the time you get your patent, may have moved on and evolved and grown so much that this patent that you spent all of this time and money getting doesn't even cover your product anymore. So it's kind of a nonsensical situation for a lot of people. Now, I'm not saying that patents are bad and trade secrets are good, but patents are just less attractive than they used to be.
Thanks, Chris. Yes, you covered many important points here. And this then leads to my next question, which is what are the key events that present the most trade secret risk then? Because we've seen a lot of risk that you mentioned for patents and how it's less attractive these days. So could you care to discuss on those points?
Absolutely. So there are three major time points where people see or encounter risks around trade secrets. One of them, everyone thinks of without fail. The other two are often overlooked, or at least they don't have as much attention given to them as we at Tangibly feel they should. So the one that everyone thinks of is when existing employees leave the organization. So everyone is worried about, my employee who had access to all of this valuable trade secrets is on their way out the door. And worst case is they either start a competing business or will go and work for a competitor. So this is the one that everyone worries about and stays up late at night about, what is the risk? How do I handle this risk? What steps should I take to lower that risk? So that's the one that gets all the attention. The other two, the first one is actually the opposite. So when you're onboarding new employees, and again, everyone's excited to hire someone. Their first couple of days, they go through HR training, technical training, all of this stuff. But no one pays attention to the fact that they might be bringing in trade secrets from their previous company. No one pays attention to that. But it's really important, first off, to remind them that they should not be bringing in other people's trade secrets. And those trade secrets should not be incorporated into products and services that they'll be developing in their new job. But there might also be other contractual obligations that they had to their previous employer, like a non-compete or an anti-solicit clause or other things that may actually affect their ability to work and be effective at your company doing the hiring. Again, everyone is just excited about having them join, but not enough attention is going into these kinds of questions. And then the third one, which equally no one really thinks about, is collaborations or other interactions with third parties. The reality these days is no one company can be successful by themselves. Maybe 100 years ago that was true, or even 50 years ago. But the way that technology works and the way that products and services are developed, you're almost required to interact with other parties. It could be in the form of a research collaboration, a joint development agreement, a license, dealing with vendors and suppliers. In order to be successful, these conversations are essential. And it's not only your trade secrets that are going to them, but it happens just as often that their trade secrets are coming to you. And you need to be really careful in the first case to make sure that they handle your trade secrets properly and use them for your benefit, but not use them in a way that's not allowed or that would somehow harm you. Like if they take your trade secrets and use that to help a competitor of yours, that would obviously be a very, very bad thing. But also, you as the receiver of trade secrets, you have to be careful about contamination risk. So you don't want their trade secrets to spread within your organization and maybe end up part of your new products and services. And they obviously wouldn't be very happy with you if that were to happen. So you have to be really careful in both directions that trade secrets flow. So in my mind, those are the three key time points where you have the most risk. And really the most attention and care should be put in to lower those risks and get them as close to zero as possible.
Thank you, Chris. Really well and clearly explained about the different time points. And I totally agree. And everybody talks about trade secret. It's only the first case, an employee going to a competitor company, and that's mostly what we hear about in a lot of the big cases, but definitely so important for the other two time points too. So, in your opinion, or from your experience, what are the top 3 tips that companies can maintain a strong protection for their trade secrets?
Sure. Thanks, Tita. And again, the magic number for today is 3. So 3 top tips. The first one sounds simple, but it's really the most effective, which is just educate your team, educate your workforce. In terms of an ROI or return on investment, having a good education and training system pays the biggest dividend. What we've found is a lot of times trade secret problems happen not because someone was doing something bad intentionally, but because they just didn't know better. Maybe they weren't trained, maybe they were kind of naive, maybe they thought what they were doing was okay or normal, but it was actually a bad thing. And these types of people, that I often refer to them as good people doing bad things, are the most addressable through education. So if you educate these people on what is a trade secret, how do you handle them appropriately, what to do or what not to do, the risk of them causing trouble goes way, way down. Ideally goes to zero. Those people are much different than a bad actor. So, and which I call bad people doing bad things. Those are the ones that everyone hears about in news stories or in court cases where someone intentionally stole 4,000 documents on their way out the door to work for a competitor. Those people are much harder to address because they're intentionally doing something that they know is wrong. But by having a good training system or education system, you're projecting this image that we take trade secrets very seriously. And we want everyone on our team to do things the right way. And if this bad person still goes ahead and does a bad thing, you at least have a good story to say, we as an organization did everything humanly possible to protect these valuable assets, and yet this bad person still did a bad thing. So I think that you're sending this clear message to your team that trade secrets are important. So again, it's probably the best investment of time and money you can do is on training. So that was the first part. The second one is just, it sounds kind of silly, but understand what your trade secrets are with some degree of specificity. It used to be that you could be very fuzzy and hand waving about what your trade secrets were. What we're finding, the trend is, especially in court cases, is the courts are requiring a trade secret owner to be very specific and very clear about what their trade secret was that they're alleging was stolen or misappropriated. You can't be fuzzy and hand waving anymore. Maybe 5 or 10 years ago you could, but now that just isn't enough. And it's not only technology, but business also has trade secrets. So again, a lot of us who come from an IP background tend to think in terms of protecting technology. And those trade secrets are still very valuable and very important. But the business has a lot of trade secrets of their own that are equal or maybe even more valuable than the technology. And it's things like customer lists, vendor relationships, pricing models, business strategies, competitive intelligence. All of this stuff is completely unpatentable, but very important and valuable trade secrets. But again, you need to know what they are in order to realize that they've been stolen, or you need to know what they are to go and enforce them at court. You can't just be vague and fuzzy about it. And then the third top tip that I would have is to be very upfront and honest with people about your trade secrets. And if you're going to share a trade secret with someone, tell them, this is a trade secret. This is really valuable. And we expect you to treat it with care. And ideally, even get an acknowledgement from them that I realize this is your trade secret. I am going to do good things with it, and I will not do bad things with it. And all of this really feeds into telling a good story if something goes wrong down the track. Yeah, if you can say, I told them it was a trade secret, they acknowledged it when they received it, there was a contract that allowed them to do certain things and not other things, and they still did something bad, you've painted a very compelling, great story for why you should prevail at court or in arbitration or whatever venue you're handling this dispute in. So it's really teeing up a good argument for you in the unfortunate case that something goes wrong later. So those are my top tips.
Thank you, Chris. All very interesting points. And yeah, from a funding point of view, it is really crucial just to understand these points. And so that when we do the due diligence and we know the key points to assess. So yeah, definitely. This leads on to my next question. Would you mind sharing some case studies and how the Tangibly platform have provided help to these companies?
Absolutely. And just for a little bit of context, Tangibly is a startup company that is a SaaS platform designed to facilitate identification and management of trade secrets. So we are, in a way, creating a toolbox of tools that make it maybe not easy, but at least a lot easier to handle trade secrets in a way that meets best practices. And again, should something go wrong and you find yourself in a dispute, you have done more than what is required, more than the reasonable measures that courts are looking to trade secret owners to have a chance at a good outcome as part of that dispute. So we're relatively new, but I do have a couple of examples from real customers that have found Tangibly to be extremely helpful. So the first one is an agriculture biotechnology company that is fairly new, but they looked at their IP portfolio and realized it was very thin, almost to the point of having nothing in it. And they didn't really understand what trade secrets were and how to manage them. So they were a perfect case for us at the beginning. And they were able to use the Tangibly platform and the workflows that we have built in to do exactly that. They were able to assemble a catalog of their trade secrets. They were able to integrate trade secrets into their patent workflow very effectively. And as a result, they were able to share this catalog, for example, with an investor. So recently, they were doing a fundraising round. And before working with Tangibly, if an investor asked them, what does your IP portfolio look like? They wouldn't have a great, compelling answer because they would have no patents, a couple of trademarks that were unregistered, and that's about it. But suddenly they were able to share under NDA this extensive catalog of trade secrets. And they're able to tell a story about how they have a great process and their technology is best protected using trade secrets, going back to our first question from today. So they were able to tell suddenly a great story by virtue of having the right tools and the right toolbox at their disposal. And even later this week, I'm attending a luncheon that they're putting on for their top trade secret contributors. And this is something that is relatively new. A lot of companies reward top inventors, and they've been doing that for 20 years or longer. Every year figure out who were the top inventors, who had the most new patents. But by having a tool like Tangibly, you can do the same thing to reward this behavior on trade secrets. So you can figure out who contributed to the most trade secrets or who contributed to the most valuable trade secrets and have some form of recognition. It could be a lunch, a dinner, an award, a voucher to their favorite restaurant. But just suddenly you have a way of recognizing and rewarding people contributing to this valuable asset that would have been, again, difficult or impossible to do without a platform like Tangibly. So that's my first case. My second one is a large multinational law firm, kind of the polar opposite from a small ag biotech, but they're using Tangibly internally as a tool. What they used to do is provide fantastic client counseling on patents, trademarks, and copyrights. But trade secrets, they would typically wait until there was a problem. So an employee stole something or a partner went rogue and suddenly used trade secrets in a way that was undesirable or unattractive. And then the law firm would swoop in with litigators and do what litigators do. But by having a tool like Tangibly at their disposal, they can provide proactive counseling to their clients on identifying trade secrets, how to handle them well, to make sure that contracts are recognizing and protecting trade secrets effectively. And it's really provided almost a new revenue stream for the law firm, where typically their billings were mostly on patents, trademarks, and copyrights. Now they can also provide counseling and billing opportunities around trade secrets, which is something that they didn't do before. So they're excited to use the tool, but in a radically different way from biotech companies or other manufacturing companies.
Thank you, Chris. That was really interesting. Yes, did not know that a multinational law firm can also utilize this like and all the just the potential that it could bring to. So this also leads me to the next question because, sharing it with the investor, has the data or the catalog been ever used in court, or is there any case studies on that?
So this is actually my favorite question. I love this question because it's a simple question with a little bit of a long answer to it. So the very short answer is not yet. So Tangibly has not made it into a court case yet. It will happen. It's statistically so likely that one of these days it will happen. But we're a relatively new company, only about 3 or 4 years old. So it's still early and we're still building our customer base. But if you look at studies from all around the world, the numbers vary a little bit, but between 20% and 50% of surveyed companies are saying that they have had trade secrets stolen. I look at that number and think it's probably more like 50 to 80% because some companies are just not aware that their trade secrets have been stolen because they're not paying attention to trade secrets. The other group that makes me think it's a much larger number are people that are just embarrassed or don't want to admit that their trade secrets have been stolen. So I think it's really much higher than 20 to 50%. But even that is kind of a shocking number. 50% is huge when you look at all the countries in the world. So to me, litigation is coming. It's bound to happen. And I kind of have mixed feelings about it. On one hand, I would like all of our customers at Tangibly to never have a serious trade secret problem. In a way, that's a best result for me because it says that using Tangibly and all of the tools in our toolbox lowers your risk. And the whole time I've used the word risk over and over, if you do things correctly, your risk will go down. Your risk of something accidental or inadvertent will go down. And even your risk of someone intentionally stealing your valuable assets will go down as well, because having best practices acts as an incredible deterrent to someone because they will either respect you or maybe even fear you if they do something wrong around trade secrets. So in a way, I'm hoping that our clients never have to go to court and never have a serious problem. On the other hand, it would be wonderful in a way if a court were to say using Tangibly more than satisfies best practices or more than satisfies the reasonable measures that are required by courts. So again, I have kind of conflicting feelings on do I want our clients to end up in court or not. But again, I think just the reality of business these days where people change jobs very rapidly, people work from home all the time, including myself, there's more and more risk of trade secrets being lost or being stolen. And again, at some point, almost every company in the world is going to have a trade secret problem. And it's up to them, first off, to realize that their trade secret has been stolen, which they have to pay attention as a gating event to make sure that they're aware. But then more importantly, they need to have systems and procedures and workflows in place before there's a problem. So that way, once they're aware of a problem, they can act quickly and decisively to control the damage and to limit further distribution of their valuable trade secrets. So at Tangibly, we're really keen to help people lower their risk and put themselves in the best possible position for success should something go wrong later on.
Thank you, Chris. We covered a lot of ground in the past 20 minutes. So is there anything else that we haven't covered that you would like to add?
Just one. And a lot of people have this mindset of patents or trade secrets. And I encounter this routinely where people feel like they're at a crossroads or a branch in the road and they have to choose one path. categorically, that's wrong. And if you use trade secrets wisely, it becomes patents and trade secrets. These two types of IP actually complement each other very well if you know how and if you're thinking holistically. But thinking in terms of or is really a trap that most of us, due to our training or our previous career, keep falling into. And it's this idea of trade secrets being less attractive or a consolation prize if you cannot get a patent. And I always talk about trade secrets are no longer plan B. And what I encourage people to do is really take a step back and think about what they're trying to accomplish in protecting their products and services and how can they use these two forms of IP, actually use all forms of IP, including trademarks, including copyrights, including patents, to give a really solid holistic protection for their business. And if you've done that, I think you've done your job very well. But if you leave out any one part of that puzzle, you're not providing the best protection to your customers or your clients. And especially if you leave out trade secrets, you're doing a horrible job of maximizing protection for your products and services going forward. And with the way the world is changing, I think there's still a place for patents. Don't get me wrong, I'm not anti-patent by any means. And especially for certain industries, patents are still extremely important. But again, if you look at ways that the different forms of IP complement each other, you can really do your job well and protect your company as well as possible. So I'd encourage people to really change their mindset and to learn more about trade secrets, learn about what they can and cannot do, learn about how trade secrets can protect things that are completely unpatentable that maybe you've never even thought about before. And really just continue this conversation that we're seeing in the media, in conferences, at presentations of trade secrets are arguably the most exciting, most rapidly growing form of IP in the world. It's a really exciting time to be in the intellectual property business and super, super exciting for those of us who practice in the trade secret arena. So it's been great talking to you today. As you can tell, I'm personally excited about trade secrets, and all of the rest of the team at Tangibly are working really hard to come up with tools and a toolbox that make life easy and allow people to protect these assets as well as they can.